got a new consultant about to start.
It is very exciting. I'm really pleased about that. So it didn't take very long, but
So when does she start?
Annie starts on the 12th. So yeah, about 2.5 weeks.
Very good. And we're, I think, about 2 months away from our big move back into the city.
Oh, very exciting.
Nice.
It's a pretty swish. Is it a swish place?
It is a swish place. And thank you out there for supporting us and allowing our growth to do it. But it's, yeah, I think all that stuff are very excited by it.
Yeah, and I think it'll be great for our clients and our community to be able to drop in and visit us when they're in town as well.
Near a train station, what can I say? Bus station, train station.
A block away from Yum Cha for any Yum Cha fans.
There's a lot of Yum Cha fans here. There'll be a lot of weight gain very shortly. Anyway, look, let's jump into it today because we're doing a number of things today. We're going to talk very briefly, I think, returning back to talking about out-of-work behaviour. I'm going to go into next week some really interesting things that extend on that. We're going to produce a very detailed article about external criminal behaviour and look at what's called the spent convictions legislation. So that's for next week to really get people to understand what you can and can't do. But today we're going to have a look at a few cases first, and then Karen, we're going to come and have a chat to you a little bit about your experience in dealing with prior convictions as you go through the recruiting process. Mm-hmm. I'll talk a little bit about post-recruiting, and you've got someone who hasn't disclosed. What can you do and what can't you do? And then we've got a fun case study based on the new Victorian Spent Convictions Act, which I'll talk about very briefly as well. Okay. So look, the first case today is Wong and National Australia Bank, who was a senior manager who was terminated, and the basis of the termination was poor performance. Case raises some very interesting things because senior people, we often are, when they're terminated, become quite aggrieved by the nature of termination, because they're on a trajectory towards where they want to get, and a termination for cause damages that trajectory. And people lose judgment and start fighting quite ferociously around it. And this is a case which is all about a misplaced fight that should never have occurred. Ms. Wong said that it was adverse action. She raised complaints about the manner in which she was being managed. She said there was no legitimate reason for terminating him. And on top of that, an issue I want you to think about a lot, the communication that followed saying that she'd been dismissed for performance defamed her as well as was adverse action. The judge is Justice Snadden, who 2 or 3 years ago was a barrister we used to regularly use, quite an academic judge. But he very quickly came to the heart of it and said, look, Ms. Wong's come to court and relied on the reverse presumption, adverse action. In other words, I make an allegation against you, you're the employer. It's you who has to prove it didn't occur. And that sounds fine, but if you look at the history of cases and adverse actions, very few are successful. In fact, we're dealing with 2 today that failed. Because nobody likes someone turning up and just saying, well, you prove it. And the second part is, when you go to prove what your intention was, it's not the objective intention based on what the evidence and the facts were. Was it a good decision that you made? It's actually what was going on inside your brain, subjective intention. And that was the problem with Ms. Wong, because what she did through her counsel was continually attack the veracity of the decision that was made by the decision makers as being unsound and without a proper basis. And the judge said, well, I know you're doing it, but it's actually not the test. The test is, who is the decision maker? And this is why we always say when you're dealing with a contentious employee, make sure you designate the decision maker and you quarantine the reasons why they're making that decision and you document why they're making that decision. In this case, for the 2 separate issues that arose, the decision makers' reasons were performance related, right or wrong, but therefore the adverse action failed because Ms. Wong couldn't lead any evidence of any other type of thing. All she could do was attack the veracity of the subjective intention. But the subjective intention stands so long as it's well documented and preserved and believable, and it was. Defamation claims are a really interesting thing, and we talk to people to be very careful about how they communicate after someone's been terminated. But it's not defamatory to say, I've terminated, Karen's employment's been terminated for these reasons. It's not. And there's very good defences that sit it, like justification, you're allowed to say it. But what I want you to think about when you're going through a termination process is, what are the 2 things you're trying to achieve? What's the internal communications that says, this is what good looks like? And secondly, be careful not to trash someone's reputation on the way out, because there's no really upside in doing it. So think about that. The defamation claim also failed on more technical reasons, but it is a stark reminder for you of the things we keep telling about. Identify a decision maker, quarantine that decision maker around proper purposes, proper reasons for termination, not whether someone's raised a complaint, not whether someone's a woman, whether someone's old. Quarantine and then document the decision-making process right down to the letter and the communications it's made, so there's internal consistency. Because the answer is the employee will never have evidence around of what the true decision was.
Mm-hmm.
It's always going to be left to you to prove it, and you're going to have to be a reliable witness as to the reasons you did it. But the veracity of whether you're right or wrong, not that important. Okay.
Yeah. And in closing that out, what you said earlier about the communications piece, we always reinforce all the time the importance of making sure that that closure is very, it's safe, it's dignified, it's respectful. There's good reasons for that too, aside from it being the right thing to do.
Yeah. Other thing, 2018, for those who are excited by things that happened a long time ago, WorkSafe Australia published their final report on the WHS legislation, and around about page 135, it's a long report. They talked about insurance against penalties. So up until around about 10 years ago, you could get insurance in relation to legal fees. And there's a whole lot of law firms who set up practices around that. But then they set up insurances for actual penalties. Now, that was never for penalties which were criminal in nature. So they couldn't have been reckless endangerment or industrial manslaughter that have jail sentence attached to it. But you could get insurance for other penalties like primary duty breaches. It's very common now to do it. New Zealand, around about 6 years ago, outlawed it. As they adopted the model legislation, the Australian model legislation, they added banning insurances. New South Wales did last December, I think it came through, and in New South Wales you can no longer insure against penalties, and Victoria have introduced into Parliament on the 22nd of June a bill that outlaws it with very, very significant fines, $250,000 for an organisation. I think it's 270,000, 55 or plus thousand for an individual who seeks to insure or gain the benefit of it. But these are things that are going to flow from that report that came from Safe Work Australia. There is no other legislation out there, but there will be, because the absolute clear evidence is when people insure for penalties, they don't take the mitigatory action. They'll actually use the insurance as a buffer from applying safety changes. So can you just be aware, safety insurance is on the nose. The cost of it is now going to start going through the roof as the two major populous jurisdictions ban it.
Mm-hmm.
For Victoria, that ban will probably come into effect, I reckon, about September next year. It'll be 12 months after assent to the legislation. It's just gone to the lower house for the second reading. So we're 18 months away from 2/3 of Australia's population not being able to get insurance for penalties. So just letting you know what's happening. Thought I'd tell you about a case called Baxter and Surfside. Another really good case on the issues we've talked about. Baxter was a person who claimed to have been bullied, had a successful workers' compensation claim. After a period of time, was unfit to undertake the inherent requirements of jobs in New South Wales. So the obligation period was 6 months. You understand Victoria, it's 12 months. It varies throughout Australia what that obligation period where you can't terminate someone. They said, we don't have capacity, and they had an assessment that said, you don't have capacity. Remember, the test for incapacity is not fit now with the reasonable adjustments, not fit in the foreseeable future with the reasonable adjustments. Baxter focused constantly on how unfair it was and how it was based on a protected attribute. They'd made complaints about bullying. They had a workers' comp claim, both protected, and Surfside said, no, it's just your capacity to work. Now remember, subjective intention, this was an adverse action. Right or wrong, they had evidence of who the decision maker was and what it was, and all the documentary evidence went to incapacity. Baxter was so busy fighting, failed to actually provide any medical evidence to the contrary. And therefore, her adverse action claim failed.
Mm.
So I just keep reminding you how important is identifying the decision maker, quarantining the decision making, creating a chain of documentation that evidences the decision maker's subjective intention, which is not unlawful under the Fair Work Act.
Mm.
Can we just be clear about how important that is? Which means when we're dealing with a complex employee where you know it's running to litigation, and nearly all of these adverse action claims are people you could smell we're going to bring a claim.
Mm.
So before you start, sit down, map out your strategy, map out your documentary process. Be careful to say, look, don't tell the decision maker stuff. They don't need to know. Focus on what is the issue. Then document. Anyway, I won't rave on about it anymore. Just to show you, in the last 4 weeks, there's been about 3 or 4 of these claims dismissed, and everyone worries about getting a Morris Blackburn or a Slater's letter that says adverse action. And you shouldn't worry about it if you've done your documents well. Okay, into the second part, which is Karen's Corner. We're getting close to it. We've produced, or Nina's produced, an updated industrial manslaughter analysis, which is now on the website, or I think Sophie's about to go on the website, which includes Western Australia now. So you have a thorough analysis of every jurisdiction with industrial manslaughter legislation. Won't go through it today, it's there. I know that Joe from Western Australia wants to update a bit. It's there, and if there's questions that people have, we're more than happy to talk about that in the future. What we're going to talk about today was pre-employment criminal behaviour and post-employment criminal behaviour, and whether it is unlawful to take that into consideration in employing someone, or what you can do once you find out about it. So let's start at the pre-recruitment stage, and I'll throw to Karen at the end of this brief discussion. And can I say, Matt and Julie are about to provide a very detailed article along with tables that sets this out in a way that makes it sense, because this is a very complex piece of law. Criminal convictions are not a protected attribute, okay? So the Human Rights Act does say that you're not allowed to take into consideration irrelevant criminal convictions. I think I'll put that back to front. You are allowed to take into consideration irrelevant. You're not allowed to take into consideration relevant criminal convictions. The problem is it's a completely toothless tiger, because they can't do anything other than throw it into conciliation. They can't proceed to hearing, and it's not a protected attribute in any other jurisdiction. So it's something that says you can't do it, and the worst they can do is report you to Parliament. That's it. And much worse things happen in Parliament every day. So that said, the important thing to remember is, yes, you can get into trouble for unfair dismissal in it, without a doubt, because if it's not a relevant matter, it's not a valid reason. So when you talk about recruitment, you look at the nexus between the nature of the criminal activity and the nature of the work being undertaken. And if the criminal activity that you seek to say, no, I can't give you a job, so I've got to drink drive, but I'm not placing anyone at risk, I'm a clerk. Well, it's not actually relevant, actually, towards that person's employment. But if it was a large-scale theft and you were a CFO, the nexus would be created. Karen will talk more about that because of her experience in the past, but I just want you to understand it as the nexus. The next thing is, in many jurisdictions, there's now what's called spent convictions legislation, which means you won't see it on a criminal record, and you're not allowed to take it into consideration if you find out about it in another event. And to do so in Victoria, which has become law, but really comes into effective law on the 31st of December, that would be unlawful and would be part of a protected attribute under equal opportunity legislation. So if you take into consideration a conviction that is spent, and that is in Victoria, something that a person was sentenced to less than 30 months in jail, there's a number of layers, and was more than 10 years ago, because it's based on rehabilitation, you take that into consideration, it's unlawful, and the person will have a protected attribute under the equal opportunity legislation. We'll try that out in the problem a little bit later. Once somebody has been employed, and we look at the whole range of cases around that, in this article that's going to come through, the issue is this: did you have the documentary paperwork that said, A, it's relevant for you to disclose, you're obliged to disclose, your employment contract should also always have a representation clause, and that goes towards qualifications and a whole lot of things, which says you warrant that the representations that you say are true. You recognise that if they are not true, it is serious misconduct. And we've seen people who run universities who don't have a university degree. We've seen principals of schools who haven't been trained as teachers. All those things should be picked up in the very first flush. But you must have a representation clause and a requirement under the contract of employment and offering that a police check is done. And then, after Wakim's case, if you don't act upon it once you find it out, it won't be a valid conviction. Because if a year goes by, it's clearly no longer serious misconduct. Okay. And the last thing to remember is, if people make false representations to you at the time of employment and you subsequently find it 3 years, 4 years later, it was a lie, whether it's about their physical condition, whether it's about their qualification, or whether it's about a relevant criminal conviction, it's serious misconduct.
Yep.
It's a valid reason. And the issue then comes is, would it be harsh to do it? And that looks at that connection of out-of-work behaviour.
Yep.
Okay.
So and also how quickly you act on doing something based on discovering that information or that information.
Yeah. And so can I just say, as we look towards employing people, 2 things I want you to think about is, what is your recruitment process that Karen will drill down on? What does your contract say? So this process has, if you wish to come and work at FCW Lawyers, you'll be subject to criminal check. Once the offer is made, the procedure will happen. You may be employed by the time the police check comes back, but if it comes back with a relevant prior conviction, such as your employment offer will be revoked. Got to be clear.
Yep.
And you've got to say to people, you're representing that you don't have these. And if you do, about your health, about your education, about prior criminal convictions, you're dead. And you must have a policy that sits internally in the organisation that deals with out-of-work behaviour, prior convictions. It must be clear what work we'll do about it. So there must be a congruence about what this organisation does. And as Karen will explain, and then you must act on it. So Karen, over to your experience, because you recruited on very large scales for international employer.
Yep, I did. So I just want to add to that what you just said there, Andrew, around in terms of making it clear in contracts is also there are mechanisms in place for people to be able to disclose, because this is really about honesty and integrity in terms of making sure that we can consider the information, how relevant in terms of that nexus as well. It's something that's happened in their early teens in terms of shoplifting might appear now because they're 25 and working for you, might still be there. How relevant is that considering the time that's passed, their age, circumstances, and stuff like that? So
that actually goes to harshness, by the way. So when you look at whether it be valid to terminate a person later on, the relative severity and nature of it goes to harshness. Okay.
I'd still want to know there and then, rather than kind of something surface later. Do you know what I mean? So certainly when I've done this before, particularly in large workplaces, and I'm talking and framing this in the logistics space, had to recruit I'm talking about tens, hundreds of people throughout the year. We have a process in place, and our controls were that in the contract, we're very clear about what the requirements are around pre-employment checks. Those checks are relevant to the role, okay? So, for example, if you're going to be a driver or if you're going to be working, if theft is an issue or a concern that our clients would have, and therefore they want us to provide the assurance that people who don't come from a background where this is problematic or the risk is there, that's the reason why those roles would be subject to a number of different types of checks. And it also means that where issues arise around if there is theft or if somebody loses their license as a result of drink driving or they're drug and alcohol affected and they're operating machinery, those things become relevant because we make it very clear that that's a requirement in terms of them being able to fulfil their jobs properly.
Okay, and that goes back to inherent requirements.
Yes, absolutely.
So that's the thing I want you to remember. When we talk about structure, be really clear in your job descriptions as well as to what are the inherent requirements, and they include the management of these risks.
Yes, and also these qualifications. You must have a current valid license, or whether it's a driver's license, forklift license, whatever it is, working with children's checks, etc. So just so in terms of that, and because we have a pre-employment check process in place, to be able to get onto that as soon as possible. Andrew mentioned earlier, sometimes those checks, people start before the outcomes of those checks are provided, but you've got to have the process in place. So when those issues do arise, you can actually manage it. Now, the other, I won't say complication, but what I've also seen previously is that something does arise and you don't manage it, or you manage it based on the person because, you know what, but you work so hard and you're doing so well and we'll let you go. But we do something different here. That's quite problematic. And that's where I've seen, that's just poor management, HR practice. But look, more generally, Andrew, I think when it comes to just organisations and their workforce, I think the question needs to be whether you're a member of the executive team or someone who's at the front line, a sales rep or, a bank teller, or you need to really identify in terms of where the risks are across your workforce and business based on the roles. Based on that, there's all these pre-employment checks, whether they're bankruptcy checks, whether they're police checks, they're driving offence checks, all these things that can be done, we'll be able to assess in terms of what's the need, what's the appropriate checks for those roles given those risk profiles. From there, it's about having the processes in place to make sure that they support what you're trying to do and managing it fairly closely as well, because having a process and a framework in place alone doesn't work.
Can I just talk about what the safety issue is that sits behind this? And Karen and I have both alluded to this appalling situation that arises where you've employed someone before the check comes back. I say appalling for this reason, because that is a safety issue. So just imagine in the meat processing industry, and the Q fever check is one of them. So the check on them, the person says, yeah, I'll go and get it, but doesn't go and get it. So they come in, they start working, they've not been inoculated for Q fever, and they get it, and they nearly die. Straight down safety issue. A person who's not safe to work with children comes in and works with children. Third-party liability risks that sit under safety legislation. A person who has problems with alcohol and drugs comes and works as a truck driver. Kills people. Do you see where the safety risk comes? We keep thinking that employment law is a silo. It's not. All workplace law sits across all workplaces all the time. So if your system doesn't say, before someone starts, we have this, enormous pressure from production saying, look, just bring them on, we can't wait, wait.
Absolutely.
All of us are going through that, particularly at the moment, frontline, that people working from overseas. There's a whole lot of roles where we're shoehorning people to get them in. Understand it's not just an employment risk you're taking, it's a criminal risk you're taking under safety law. That's enough of that. I've gone far. So, Soph, can you bring up our question for the day, our case study? I'm going to have to lean in on this. I want you to remember for this case study, because we're talking about the future, just so I can focus on spent convictions legislation. Remember, the spent convictions legislation will take effect probably from 31 December this year. And that means that anyone who in the 10-year period, more than 10 years before, had a conviction for an offence which had less than 30 months of imprisonment, that'll be erased from their record. You won't see it. So let's go to this case study. And that's why it looks forward, because I didn't read that before I created the study. All right, John is a cleaner at King Clean with access to client office buildings. He commenced employment on 1 June 2018. During his recruitment, John was asked to disclose any convictions for dishonesty. No police check was undertaken at the time. He had been found guilty and sentenced to 6 months jail. I don't think that's right, actually. Yeah, no, that's that. Yes, right. Sorry, 6 months jail for theft as a cleaner in September 2010. I wrote this after I got back from dinner the night before. On 22 April 2022, that's next year, guys, when he was cleaning a law firm's office in the city, a lawyer recognised him, recalling he had represented him at the trial of his theft charge. He told the office manager, who told the owner of King Clean, Mr. Bud Weiser, I thought that was a nice touch after dinner, that they would not allow John to work in their office. Bud confronted John about his past criminal behaviour. John said he didn't have the conviction and was happy to do a police check. The police check showed no prior convictions. By the time Bud did the search, his conviction was removed as it was spent under the new law. Bud spoke to the client, who produced the file with the conviction on it. Bud sacked John for dishonesty. I don't think there's a second page. All right, so does everyone get it? That's a complex issue, and it's what you're about to focus. So here are the questions, and your time starts now. And were there questions that were being asked there that we didn't answer? So I saw things jumping up on the page.
No, don't worry about those.
Don't worry about those?
No.
Why am I not worrying about those? They're Sophie telling us things, are they?
Oh, no. I think that it was a chat box that appeared that it wasn't meant to be for us. Sophie's probably freaking out right now and goes, oh,
there you go.
Trying to shut down notifications. It's okay, so.
Yes, well, aren't we lucky I'm blind?
Oh, on lighter things, we are wearing the same clothes again.
Same shirt, yeah.
Same
How does that
shirt.
happen?
I don't know. I don't normally wear a collared shirt. And the one day I decided, you know what, just to be safe, I'll wear a collared shirt so that he doesn't, because I don't normally wear them. You wear a collar shirt.
Well, look, it's after the last time when someone said, why do you wear turtleneck jumpers? And I said, because I've got a turtleneck, And after that, I've received a fair, but I do. I've got a thinnish sort of neck, and I'm getting out from under my shell. Yeah, so I thought I'll hang loose with a denim shirt, and then you turn up on the same thing. What's that about?
Yeah. Well, you wake up earlier than me, so, you're right. whoever gets up first and gets dressed first, gets to
we're the
claim
only.
it.
That's right. Now, how are we going with numbers there?
We've got 73% who's voted for 75, so probably another 5 seconds. Okay, we can wrap that up. Okay, 3, 2, 1. All right, excellent. Thank you so much. Let's share the results. Now, Andrew, I'll try and make this a little bit bigger so you can see it. There you go.
All right. So the first question was Bud's termination of John's action was an anti-discrimination claim. So could John bring an anti-discrimination claim? Well, the difficulty really in all of this is that John lied. And lying, I'm afraid, is serious misconduct. Yep. This is not really a spent conviction issue. Okay. Problem is, and we'll come to adverse action shortly, if Bud's decision was based on the spent conviction, naughty, that will be protected under the equal opportunity legislation at that time. So it could be discrimination and it could be adverse action. But if properly formed, the intent of the decision maker is, no, you lied to us, you were asked and you failed to disclose to us. And at the time at which that occurred, it wasn't a spent conviction, it was something you ought to have disclosed, then it's probably going to defeat the claim. But the difficulty in this is there was no proper process. So can I just say in relation to the discrimination claim, there is some real risk that sits around this because A, they were shown a file they had no right to see that was protected by privacy law. 2, Bud's decision was made on the basis of something which was no longer something he could know about by getting a criminal record check or rely upon for the purpose of law. It was a protected attribute. So that conviction, so the only issue here that they could have terminated on was dishonesty. Okay, does that make sense?
Yeah.
So that really answers also the adverse action issue because remember in discrimination, it is an objective test. So it is the test of saying, did I treat that person differently than I would treat somebody with the same attribute? Okay. So the answer here is, I don't think a discrimination claim would get up except for the way in which Bud found about it. And if he relied upon that, then objectively that was the basis of the termination discrimination claim works. Okay. Same with adverse action, because there's no doubt that Bud's mindset was based on being shown a file that proved that a wrong had occurred at a time when he had no right to look at that entitlement, given the police check that he'd had. No right at all.
So, Andrew, if someone, let's say that they had no right to consider that a spent conviction, but so they can't do anything about that. So even if they volunteered that information or if that information came from other means, let's say another colleague or a friend had mentioned that, look, hey, did you know about so-and-so's past? This is what they did. That's still irrelevant. It's
still irrelevant, can't be used. And the idea is it came from some UK legislation that started spent convictions, which provided this time frame because it wanted people to be able to reform and return to society and be treated fairly.
Yeah.
And that's why there's this threshold in sentencing.
Yep.
Now there's certain types of crimes that are exempt from that. And pedophilia type crimes and things will be exempt and they will come up through police checks, particularly around working with children. Okay.
Yeah.
The last thing is, was it an unfair dismissal? Tell you what, this one smells of an unfair dismissal. So was there a valid reason to terminate? Well, because discrimination law and adverse action are not the things that motivate unfair dismissal. But if you said on the basis of dishonesty, yes, okay, then you've got a valid reason. But the process was so flawed. Now, what the cases say is based on the nature of the criminality involved, you can move from procedural fairness. So that can fail. But this is not a serious crime.
Yeah.
It is an old crime. And there's no evidence at all that he's had misbehaviour during the life of his employment here. So it would be harsh. He would be successful and he'd be reinstated. And for the lawyer involved, there would be very, very serious issues about his professional conduct, and he would be up for professional misconduct for showing the file. I'll just say that for the lawyers out there who forget, there's ramifications for disclosing client private information. Really big issue. So look, interesting. So what I want to do, there's a couple of things for next week I want to do. Matt and Julia are going to pull together this great thing on criminal behaviour, and we'll spend a bit more time on it because we've had a lot of discussion about it. and we'll break it down into bite-sized chunks about what you can and can't do.
Yeah.
The other thing I wanted to do was to talk about overwork claims. That is where, by the nature of the work we do, we start to push, and this is a particular case in remote working, we start to increase the loads on people and they develop stress-based claims.
Mm.
I want to talk a little bit about that and how to manage it. Other than that, I'm going to try and wear something that Karen will never expect next week and try and be different.
Yeah.
Not that our firm's not different anyway.
Yeah. Leopard prints, Andrew. Leopard prints. Consider that. Anyway,
No.
we're over time. We're over time. See you, everyone.
See you later.
Bye.
Bye-bye.